I get to introduce our speaker for today's event. My name is Doug Kysar. I'm Faculty Director of the Law, Environment, and Animals program. Before I introduce our speaker, though, a few logistical notes. First, this event is being recorded to be posted on our speaker event video series. Second, all food served at the event is vegan. Third, there will be time for Q&A after Jolene's talk, so please hold your questions until the end. Finally, we just want to thank our co-sponsors for their support and collaboration, the Yale Animal Law Society, the Yale Environmental Law Association, and the Yale Sustainable Food Program. Now, to the introduction. Dr. Jolene Lin is Associate Professor in the Faculty of Law at the National University of Singapore, where she's also Director of the Asia Pacific Center for Environmental Law. Dr. Lin is the author of numerous articles and books in the fields of climate change and environmental law. She's a prolific scholar and speaker on these topics, as well as being an extraordinary teacher who's won her department's annual teaching award multiple times. Dr. Lin is also involved in important climate change philanthropic initiatives, including serving as a pivotal board member for a foundation that is itself a pivotal funder and supporter of climate advocacy across the globe. Before joining INUS, Dr. Lin spent 10 years at the University of Hong Kong, where she was associate professor and vice dean. Before becoming a law professor, she earned graduate degrees at the London School of Economics, the NYU Law School, and a PhD in law from Erasmus University. I first met Jolene more than 10 years ago now, and quickly realized that in addition to being a brilliant scholar and an inspiring teacher, she's also a warm, witty, and just plain wonderful person. I'm proud to call her a friend and colleague, and I'm delighted she's here with us today.
Good afternoon, everyone. Thank you so much for making the time to be here and for me to have the opportunity to share my work with you. Before I begin, I just want to thank Doug for the kind invitation to share my work here at the University School, to Laurie for having coordinated everything so beautifully for me, and to two colleagues who are here today, to lend support, and to a former colleague from the University of Hong Kong who is still my very, very dear friend and remains a wonderful pillar of support as I advance in my academic life. Today I want to talk about the rise of climate litigation in Asia. In the next 40 minutes, and as Doug said, we'll leave about 20 minutes for Q&A. This is the outline of what I intend to cover. So I begin with starting with some context setting. And then I'm going to delve into 4 key cases that I want to share and talk about. And then that leads us into a discussion. So without further ado, let's do some context setting. So when we talk about Asia, first of all, it's not a monolithic region. We all know that. It's a region that's made up of many countries with very different economic, political, and social conditions. What this also means is that climate litigation is going to look very different and also emerge in quite different ways across these many jurisdictions. Here I just want to give some examples of the characteristics, or at least in some of these jurisdictions in Asia which I study. First of all, starting with the right-hand side of my slide in that yellow box. This is a list of the jurisdictions in the region of Asia where climate litigation has emerged. By this I mean that climate lawsuits have been filed and decided in these jurisdictions. I have highlighted India because India is what I consider to be a front runner in climate litigation in terms of the volume of litigation that has been filed and decided. In my work on climate litigation in the Global South, which was published with Professor Jacqueline Peel last year, we did one of our case studies, one of our major case studies was looking at climate litigation in India, looking at the trends, looking at the opportunities, as well as the barriers for climate litigation in this jurisdiction. Apart from India, climate litigation has emerged in places like the People's Republic of China, Indonesia, the Philippines, Pakistan, Korea, Taiwan, and Japan. Now, what is really interesting and noteworthy, which is something I'll come to later on, is that one of the major trends in climate litigation in the European Union, for example, has been what is called framework litigation. The term framework litigation comes from the idea that there is climate legislation in place. There is a framework law governing climate policy in that jurisdiction. Framework litigation is aimed at enhancing the ambition of that framework. It is usually aimed at trying to get the courts to make a declaration that the state's climate policy is not ambitious enough and needs to, for example, adopt a more ambitious greenhouse gas reduction target. Most jurisdictions in Asia do not have climate legislation in place. As a result, framework litigation has only emerged in 3 jurisdictions: Korea, Taiwan, and Japan. These 3 jurisdictions have had framework litigation filed, or framework lawsuits filed, because these are the only 3 in Asia which have these climate laws in place. In the rest of the jurisdictions, climate change is being addressed through the existing array of environmental laws and policies. For example, water pollution laws, air pollution laws, environmental impact assessment, so on and so forth. Now, coming to the rest of Asia, let me just give you a sense of what each jurisdiction looks like, or some of the jurisdictions look like, because it affects the kind of cases that are brought. First, for example, in Indonesia, Indonesia is the second largest producer of coal in the world. As a result, a lot of the litigation there is aimed at trying to stop coal extraction. Also, as well as to change the energy production methods from coal-based to alternative energy systems. The Philippines is highly vulnerable to the impacts of climate change because it is an archipelago of thousands of islands. The Loss and Damage Fund, established under the United Nations, is headquartered in the Philippines. It has had significant influence on the way climate litigation is thought of and conceived in the Philippines. In China, in the People's Republic of China, we have a very interesting situation where climate litigation is actually encouraged by the state as a way to advance climate policy goals. In Singapore, it's a very small city-state, it's a very small island. We have high adaptive capacity just because there's quite a bit of thinking about what needs to be done to protect the small island state from the impacts of climate change. There's a lot of focus on climate finance at the moment, and there is no climate litigation. And in Japan, what is noteworthy is that it is one of the largest funders of fossil fuel projects in Asia. As a result, a lot of the litigation strategies targeting climate finance are zooming in on Japan. When we talk about climate litigation in Asia, you have a relatively small handful of cases. A small handful of cases that are reported on the 2 major global databases run respectively by the Sabine Center at the Columbia University and the Grantham Institute at the London School of Economics. These 2 databases are synced. They speak to each other. They are coordinated, and importantly, they are the databases that are most relied upon by policy, by advocates, by civil society, and by researchers. What you see is that this relatively small number of cases my hypothesis is that there is a high degree of underreporting due to language barriers, as well as a fairly narrow definition of climate litigation that is adopted by these databases. In conversations with the people who manage these databases, it is clear that they have adopted a particular definition of climate litigation because they don't want to become over expensive, right? That's like all environmental litigation becomes climate litigation because all environmental issues can be linked to some form or some issue in climate change. So they've taken this narrow definition. In my work, what I've been trying to do is to suggest that this tends to result in the inability to capture a lot of the developments in climate litigation in the global majority. Now, when we talk about Asia, my interest in this work actually started in 2019, where thanks to Doug agreeing to co-organize a workshop with me on climate litigation in Asia, we brought together a group of scholars to think and discuss about climate litigation. Interestingly enough, there are two things I recall being very memorable when we tried to come up with the list of people that we wanted to have in that room. First, many people we approached said, what? Climate litigation in Asia? Like, seriously? What are you talking about? Like, it's not happening, it's never gonna happen, so, okay, that's not interesting. So that's one. The other was, we then had to encourage people to so-called think outside the box. Why would there be no climate litigation in your jurisdiction? What do you think are the barriers? And we'll have people who would submit draft chapters where the barriers analysis was like 90% of the chapter with like 10% on possible opportunities. And you're like, oh God, this is sad. So it was with great pleasure when last year, and since 2019, there have been some really positive developments. And it was last year where I went, oh, I can finally talk about the rise of climate litigation in Asia because there are actually notable cases worth studying. So with that, I will go on to discuss the first case in my, that's been really interesting and worth celebrating. The first case I wish to discuss is known as the Great Indian Bustard case. It's a little bit unfortunately, but anyway. I have been told that the Great Indian Bustard, which is one of the largest flying birds in the world, was actually a contender to be the national symbol for India, but lost out in that race because of the possibility that the bird might be associated with another type of a bustard. So that's why I say it's unfortunate. So here there is a picture of this incredible bird. It is one of the most critically endangered species in the world. The WWF as well as the IUCN puts its numbers in the wild at approximately 190 globally. The reasons for its incredibly steep decline in recent years is due to habitat loss, poaching, and of course, also, which I'll come to the point about it later, about accidental deaths due to collision with power lines. The bird itself is also incredibly hard to, it's not a bird that has a high procreation rate, so it has led to its decline. Now, this bird, the Great Indian Bustard, was the, I just realized that in setting out the bird, I forgot to set up the actual case name. It's actually really problematic. I think it lies underneath the picture. I will send it later. This is terrible. Anyway, I was like, why is that a bird? Where is its name? All right. So the petitioner is a very well-regarded conservationist, and he filed a writ under Article 32 of the Constitution of India seeking directions from the court for the conservation of this critically endangered species, as well as another species known as the Kysar blossom. Now, just to bear in mind that in India, which has a culture of public interest litigation, it is possible to file for a member of any one of us, any Indian citizen, to file a petition directly to the Supreme Court, seeking judicial intervention in a matter of public interest, in this case, the conservation of this bird. Now, this led to April 2021 to the Supreme Court making several orders. In its decision, these orders restricted the installation of overhead transmission power lines in an area of approximately 99,000 square kilometers in the state of Gujarat and Rajasthan in India. The reason why the area is so large is because these two states of Rajasthan and Gujarat are the places where the highest population of the Great Indian Bustard can be found. The court also directed that as a result of the possibility of the Great Indian Bustard colliding into overhead power lines, all power lines should be grounded. It should be underground across this huge area of 99,000 square kilometers. When this judgment was passed in 2021, of course the conservationists applauded the decision. It was seen as a triumph of the protection of the Great Indian Bustard. But quite immediately, the respondents, which were government agencies and electricity providers, as well as the renewable energy industry, filed counter petitions. The reason why the power industry was very much interested in this decision was because Rajasthan and Gujarat are also the places in India with the highest potential for solar power generation. There is intense sunlight for a good part of the day, almost no cloud cover, which makes it perfect for solar power generation. The respondents, including the central government, sought modification of this court order, saying that there was just no way that the court order could be implemented because undergrounding of power lines across such a big area has never been done anywhere in the world. It is incredibly costly if it can even be done, and also does not serve the purpose of protecting the Great Indian Bustard, which faces several other challenges, including poaching and habitat loss. The Supreme Court issued its decision in March 2024 by a three-judge bench led by Chief Justice Chandrachud. Now let's have a look at why this case is interesting for those who are studying climate litigation. In this case, which was about the modification of an order concerning power lines across the state of Gujarat and Rajasthan, the court formulated a new constitutional right to be free from the adverse effects of climate change. The court held that this right finds its foundations in Article 21, which is the right to life, and Article 14, which is right to equality. We'll talk a little bit more in the next, the right to equality is actually really interesting. The reason why right to equality was drawn upon was because in discussing the impacts of climate change, Chief Justice Chandrachud paid quite a bit of attention on the unequal burden of climate change on the poor and marginalized communities, on indigenous communities, and on women and children. One of the things that was mentioned in this judgment was that in rural India, many women spend up to 4 to 5 hours a day traveling long distances to collect water. And the impacts of climate change, such as increased risk of droughts, will have a disproportionate burden on women. And he said that would actually infringe upon Article 14. There was also extensive discussion of India's commitments under the United Nations Framework Convention on Climate Change, the UNFCCC, and the Paris Agreement, as well as Indian domestic climate policies in the judgment. Paragraph 25 is I set it out here in full, but I just wanted to highlight a few things. The court says, Without a clean environment which is stable and unimpacted by the vagaries of climate change, the right to life is not fully realized. The right to health, which is interpreted by case law as a part of the right to life, is impacted due to factors such as air pollution, etc., etc. Now, why I set up this paragraph is because it sets out here in this part about his example. He says here, if climate change and environmental degradation lead to acute food and water shortages in a particular area, poorer communities will suffer more than richer ones. The right to equality is that will undoubtedly be impacted in each of these instances. It's noteworthy that in the climate litigation jurisprudence thus far, a lot of cases have drawn upon right to life, but very few have drawn upon right to equality. And that is, of course, quite as interesting as a potential pathway for future litigation. This case that was decided by the Supreme Court in 2024 is actually a really interesting departure from an earlier case that was decided in 2017 by the National Green Tribunal, which is an environmental court with jurisdiction over environmental matters in India. In this case, which concerned a petition filed by a 7-year-old girl called Pandy submitted this petition arguing that climate change impacts ought to be considered in environmental impact assessments in order to better improve environmental governance in India. Here, in a 2-page decision, and I think half the page was like, half the page was like the cover sheet, and the other half of the page was the end page. So it was just like a 3-paragraph decision. The tribunal actually just said there is no reason to presume that the Paris Agreement and other international protocols are not reflected in the policies of the government. Full stop. So petition is denied. So it's actually really interesting that here in the Supreme Court in 2025 is engaging with the climate change issue in a case that it actually wasn't pertinent. But what is left unsaid in this case, which is of course a basis for some critical scrutiny, is what is the scope of this right against the adverse impacts of climate change? Who is the right holder? Well, we assume that all citizens will be the right holders, but how is this right going to be enforced? It's left unsaid in the judgment, and I would argue intentionally so, because in the Indian judicial system, oftentimes it would be left to case law to elaborate upon the scope of the right, and it would also be inappropriate given that this was a decision in arbiter for the court to have gone on at great length to elaborate on this right. But at the same time, it also leaves us all wondering, what's this wonderful right that we have now in India, in the Indian constitution? So that's what I wanted to share on this thing. Now, the case itself, the decision itself, which runs to about 60 pages, the court's articulation of the right to be free from the adverse impacts of climate change is very narrowly focused on access to renewable energy. Well, it's because of the facts of the case, right? But then at the same time, it also can be quite misleading because it seems to suggest that the right to be free from the impacts of climate change can be realized by this unequivocal commitment to renewable energy, which seems to come across quite strongly in the judgment. This leads me to the second point, which is that the 3-persons bench champion solar energy projects with no reference to the adverse ecological and social impacts of large-scale solar farms, of which there are plenty. And there have been public interest litigation cases filed in India to challenge some of these adverse impacts. And the final point that is perhaps really will be of interest to people here who are members of LEAP. It's a deeply anthropocentric judgment. There was no engagement at all with the body of case law in Indian jurisprudence that is more ecocentric that recognizes that there are other living things who are deserving of respect and rights in the legal system, and even putting aside that engagement with the ecocentrism, it is a deeply anthropocentric judgment because this leads me to my next point, which is that the court says that here you have a case which pits two interests. One is the conservation of a highly endangered bird, and the other is the imperative of protection against climate change. So it says here, the court says in paragraph 53, it is imperative to recognize the intricate interface between the conservation of an endangered species such as the great Indian bustard and the imperative of protection against climate change. Unlike the conventional notion of sustainable development, which often pits economic growth against environmental protection, the dilemma here involves a nuanced interplay between safeguarding biodiversity and mitigating the impact of climate change. So it says that. But what goes on is that, and it goes on to say, while balancing these two crucial goals, which is the conservation of the bird and climate protection, it is necessary to adopt this holistic approach which does not sacrifice either goal. But did the court strike balance? And the answer is an unequivocal no, because 95% of the judgment is devoted to the discussion about climate change and renewable energy. And there was short shrift, I think 5 references to biodiversity conservation and any of the international law that is applicable to that, considering that the court felt it was important to also abide by India's international law commitments. So, here there are 2 things I just wanted to point out. What is the significance of this new right? Well, it remains to be seen. It's quite clear that given this articulation of a new right, it will be referenced and be used as a hook for future lawsuits. So many people and commentators have been very excited about this articulation of a new right because it will be yet another argument to run in the court. And it is not unusual in Indian litigation for there to be a number of arguments raised at in the submissions, and rather than to focus on one key submission. Now, there is this thing about stealthy climate litigation. I'll just explain a little bit about that. What we have observed in most developing countries is that climate litigation strategies often try not to focus on climate change as the big issue because, first of all, it may be politically more sensible to actually focus on other environmental issues and to sort of stealthily bring in the climate change concerns. Secondly, is that in many jurisdictions where there is concerns about judicial attitudes towards climate litigation, you basically introduce climate change through marrying it with other arguments such as environmental impact assessment. Now, with this case, what people have argued is that, look, there's going to be this huge departure from stealthy climate litigation because you don't need that anymore. The court has actually even articulated this new constitutional right. I'm not going to spend time talking about Vedanta because it is a very interesting case, and the only reason I wanted to mention it, but in the interest of time will not, is because this same court that decided the Great Indian Bustard case 3 weeks earlier had ordered the shutdown of a copper mine owned by Vedanta after a turbulent 10 years of legal battles to try to get this mine shut down. And perhaps I was just being a little bit petulant, but I wanted to mention this, the judgment Vedanta, was because when we talk about climate litigation, we often forget what is the ultimate goal. And in Vedanta, in this case, Chief Justice Chandrachud quotes Amartya Sen, and he tells us, the ultimate aim of all this litigation is really to try to secure human dignity and the ability to live a good life. And he talks about how can we expect to a people to live a dignified life if we do not have basic necessities like clean water and an environment that is, that is free from the impacts of climate change. I want to swiftly move on to a very different type of case. Youth climate activism has been on the rise across the globe. And this case, which is brought by, I think I have a missing slide. That's not a missing slide. I now know, sorry. If it's not a missing slide, I just was not very good at this. I should have thought about it. The first case, that's the Korean Buster case. The second case I want to go to, which I will be calling the Korean youth case, is filed by a number of petitioners, including Do Yoon-kim. And now I have to fast forward. Apologies, that was not very good planning. It's the first framework litigation victory outside Europe. In this case, which was filed by youth petitioners, the Korean Constitutional Court ruled that in relation to the national greenhouse gas reduction targets set by the government and the legislature, the state has violated its constitutional obligation to protect the fundamental rights of its people. The decision also expressly recognized the rights of future generations. And in fact, the rights of future generations was one of the key reasons for the declaration of unconstitutionality. Now, let me briefly summarize the facts of this litigation because it was an amalgamation of 4 lawsuits. There are 3 pieces of legislation that were challenged here. First, the Carbon Neutrality and Green Growth Act, which sets out the legal framework for climate policy making in South Korea. Secondly, an enforcement decree, which is subsidiary legislation to the Act. This enforcement decree also enshrines South Korea's nationally determined contribution, which is a legal obligation upon states to submit to the Paris Agreement on climate change. So the transposition of the international law commitment is true enshrining the NDC in the enforcement decree. And finally, there was this first carbon neutrality basic plan, which is effectively an executive policy on how the Act and enforcement decree were going to be implemented. 4 lawsuits were filed against the Act, the decree, and the plan. All 4 lawsuits were filed by different groups of young people, including an unborn child who, on the day he was born, was officially added as a plaintiff, and he is widely reported in the news as the woodpecker. I have no idea why. Now, as a result of this consolidation, the case was heard and decided in 2024, and here I set out a summary of the decision. The court had to rule on the constitutionality of the Act, the decree, and the plan. The first thing, the court ruled that the Act was unconstitutional because the state basically had violated its duty to protect the right to a healthy environment, which is a fundamental right, because the Act does not provide for any greenhouse gas reduction targets for the period after 2030. So what it means is that you have these 5 yearly targets until 2030, and then after that, they say, by the time we get to 2029, we'll think about what happens in 2031 onwards, which the court, as I'll later explain, thought was pretty shoddy policy thinking. The claim against the decree and the claim against the plan was dismissed. And we'll talk more about that. So in the Korean youth case, the key question was whether the state has violated its obligation to protect fundamental rights, in this case, the right to a healthy environment, in relation to the harms of the climate crisis. The court engaged in a two-step analysis. First is to define the nature of the risk posed by climate change. In this case, it looked at a couple of things, including anthropogenic greenhouse gas emissions as the cause of climate change, looking at the harmful impacts of climate change, of which there were tons of expert evidence provided by the Korean Meteorological Agency itself. And there were all these concerns about, and there were also arguments about the global carbon budget and what should be South Korea's appropriate contribution towards mitigation. After having assessed that the risks of climate change are pretty high, the court then says step 2 is to analyze whether the state's protective measures are actually proportionate. It says that basically the test is of a minimum protection measures. You can't say that you expect the state to go over and beyond. The constitutional role of the court will be to make sure that whatever the state is doing at least pass minimum protection tests. So this basically, there are two things. Here the court goes on to say, when we talk about there is a principle of prohibition against insufficient protection. So the court cannot go below a threshold. Whether this principle is violated in a specific case is determined by whether the substance of the protective measure responding to the risk situation has the required minimum characteristics as a protective measure that appropriately corresponds to the characteristics of the risk situation at issue. Now, when such determination falls within a technical field of expertise or has an international aspect, such as climate change, then we will have to assess the risk situation based on scientific facts as well as international standards. Now, what is important in this case is the case also laid down a standard of review. Basically, the court said that when it is trying to assess whether the state has met this threshold, it should be assessed based on scientific facts and international standards whether the specific reduction targets align with Korea's share of contribution it ought to bear in light of global reduction efforts, whether the framework that has been put in place by the Korean state is designed to prevent excessive burdens from being shifted to future generations, and whether there is a proper institutional framework, whether the system is institutionalized in ways that can effectively guarantee greenhouse gas emission reductions. Now, this is important because there has never been an articulation of a standard of review, and so this will be helpful. Here I want to point out how did the court decide that the lack of a target for the period beyond 2030 till the net zero target in 2050, how is it problematic? So first, it's problematic because the court said, look, the state has already set a reduction target as early as 2009, but emissions continue to rise. So clearly you don't have a very efficient system going on, do you? Secondly, the court basically, the government basically said, well, under the Paris Agreement, we are required to update the nationally determined contribution every 5 years. That's our international law requirement. When we update that, we will also update our target in the enforcement decree. We're good. We're very good. And the court said, really, 5-year planning. Are you going to tell me you seriously don't need more long-term planning to deal with climate change? Third point. The government lawyers argue that under the Paris Agreement, there is the principle of progression. You're supposed to have incrementally ambitious greenhouse gas reduction policies. The court agreed that yes, there is that principle, but the principle doesn't offer a sufficient safeguard against governmental decisions that are prone to be influenced by short-term interests. And finally, the court said, you have these 5-year targets, but you don't actually have an overall cumulative target. So what happens if by the end of 6 5-year periods, 30 years later, you realize that you have totally overshot any sensible budget. And the government lawyer's response was, right, okay, problematic here. So on so many levels, the court said, I think we have a problem here. Go do something about your legislation. Now, the most contested issue in this case was actually the adequacy of the 2030 target in the enforcement decree. And as I mentioned, this target is actually a challenge. This effectively was a challenge of the adequacy of South Korea's NDC. The question for the court here was what ought to be South Korea's NDC, based on scientific evidence and peer comparison. So basically with comparable jurisdictions in terms of economic development, etc. Now, what was really a missed opportunity here was that the court concluded that it cannot identify a single standard for setting a target for South Korea, and it cannot be used as a legal standard. Now, this is very surprising because amongst the numerous amicus briefs that were submitted to the Constitutional Court was a very comprehensive amicus brief by the Human Rights Commission of South Korea, stating what are the scientific pathways that have been established and accepted by the international community, specifically the Intergovernmental Panel on Climate Change, of which South Korea is an active member. So, speaking of the IPCC, the Intergovernmental Panel on Climate Change has set out reduction pathways. And these pathways have been relied upon by other courts, such as the Supreme Court of the Netherlands, in the case of Urgenda and the Netherlands, where the court ordered that the state had to increase the ambition of its greenhouse gas target reduction along the lines recommended by the IPCC. So here what we could say is that with the Korean youth's case, we have a bit of a missed opportunity, and it was seen as a little bit odd that the court just refused to engage with the issue of the adequacy of the NDC, given that there was quite a robust set of information that could have been relied upon to identify some kind of a standard. The next two cases that I want to briefly walk through are cases that have been recently filed. I'm just mentioning them as sort of like areas of interest because there's no decisions yet. But I think they're really interesting because first, this case that is filed by Japanese youth is a civil lawsuit by young people in Japan requesting 10 of the largest thermal power companies in Japan to reduce their emissions and according to a rate that is consistent with the science-based 1.5 degree science target. The case relies upon Article 709 and 719 of the Japanese Civil Code, which is basically tort law. This is the first tort-based climate lawsuit against a carbon major or a company in Asia, which is why it's a space worth watching. The line of argument, as far as I can see from the submissions, is very similar to that adopted in the case of Milieudefensie and Royal Dutch Shell, which was a case that evolved around this question of whether Shell is required by law to reduce its carbon emissions by 45% by 2030 relative to its 2019 levels. Shell being one of the largest oil and gas companies in the world. There are a few questions here that are worth thinking about in light of the fact that the Japanese case would parallel the Milieudefensie case line of argument quite significantly. For those of us who are like tort lawyers, the interesting question is how would the court determine the scope of the company's duty of care? Now, what is interesting when we look at the decisions in Milieudefensie is that the court basically relied on a combination of domestic law and international soft law to determine that there was a duty of care upon Shell to reduce its emissions. However, as many of you might know, in its most recent decision by the Hague Appeal Court, the court has ruled that while there is a duty of care for Shell to reduce its emissions, it did not specify what exactly would be the level that it would have to reduce its emissions by. So it's kind of like, you have a duty, but not sure what this duty might actually entail you to do, except for best efforts, which we all know best efforts is a very hard thing to go about. The next case I just want to gently touch on is Asmania versus Holcim. Holcim is one of the largest companies in the world manufacturing cement. It's a Swiss-based company. Asmania and et al. Are actually referring to 4 inhabitants of an Indonesian island of Pari. And they formally lodged this complaint against the Swiss company in Switzerland. So it's an example of transnational climate litigation, where the litigants are based in Indonesia, suing a company that is domiciled in Europe. In Switzerland. The case involves a mix of requests, one to reduce its emissions, and another to co-finance the cost of adaptation on the island of Pari. And basically, this is a case which is one of the first to actually use the term that Holcim should pay for loss and damage for its role in contributing to climate change. This work on the case of Holcim, which also tracks another transnational case filed by a Peruvian farmer, Luia, against a German energy company, RWE, is based on a lot of the work that's been done by the Climate Accountability Institute, which has been able to identify the contribution of each carbon major to cumulative greenhouse gas emissions since the Industrial Revolution. And through that ability to define the share of contribution of each carbon major to causing the climate crisis, the plaintiffs actually seek compensation worth US $3,600 each as compensation and contribution to flood prevention measures. So one might ask, why this number? And secondly, that's it? That's all you're going to ask for? Because the point is to make this as a precedent. The sum of $3,600 is equivalent to about 0.42% of what they calculate to be the whole bill of compensation. And 0.42 is Holcim's contribution to the cumulative amount of greenhouse gas emissions that have been emitted since the Industrial Revolution. So it's saying, you're responsible for 0.42%, you pay for 0.42% of the bill. And someday we'll find someone who's responsible for 21%, and you will pay 21% of the bill. But till then, this case, which is has been filed, it was filed in February 2023, is still pending in the courts. But I thought it's really interesting to kind of highlight what is going on in this space. So thank you very much. I think I have managed to make